Hello, everyone, and good afternoon to all of our participants joining from Austria or other EU countries today. And good morning to all of you joining from the US. Thank you very much for being present at our webinar today. Let me introduce myself to you. My name is Thomas Moschig, and I've been serving as a trade counselor at our Washington, D.C. office since last summer. And in this function, I will be your host of today. Together with our Advantage Austria offices in Atlanta, Chicago, Los Angeles, New York City, and San Francisco, we support Austrian companies with all US-related matters, including trade policy and tariffs, which is the focus of today's webinar. Our Atlanta and Washington offices are primarily responsible for covering US trade issues, among other areas, and hence we closely monitor key developments and regulatory changes related to US imports and tariffs. And as shown on our front slide, today's topic is US tariff update, focusing on Section 232 today, a very interesting topic. It's October the 8th, and while the US government is currently still in a shutdown mode, the complex tariff regime remains fully operational. We have a full program for today and a lot of contents prepared for you, and only a limited time of amount of time, roughly an hour. So our agenda features two experts today in the field of trade policy and tariffs. Following my intro and opening remarks, we'll hear from Joe Maha, a former career attorney at the Department of Homeland Security with deep experience in both domestic and international policy and legal matters, as well as Jim Trubitz, vice president of a very notable customs brokerage firm, a very well-respected customs broker offering import compliance services to international customers. Both closely monitor the current US tariff developments and their impact on international companies and shipments. So you can imagine they have a lot to do at the moment. Their presentation will take approximately 45 minutes combined, and afterwards we hope to have reserved some time for Q&A session at the very end. I believe there will be a couple of questions from your side as well, and we want to have an interactive session at the very end of this webinar. But first things first, let me remind you of some housekeeping rules of today. Please note that this webinar is being recorded as we speak, so all your questions will be also recorded. The recorded video, as well as the presentation slides of today, they will be shared with all participants registered for today's events. As you probably noticed, all microphones are muted and all cameras are switched on by default. And this remains so. So our way to communicate with each other will be through the chat window, please. I therefore encourage you to also direct your questions through the chat window, and do that, please, as soon as you have a question, as soon as something pops up. Don't wait until the end. Just type them in immediately so that we can see them and make sure it's getting answered at the very end. Talking about the questions, I have prepared some suggestions for you as well. Given that we have a very strong turnout today, please make sure that your questions are more general and it affects other persons as well, because there will be a little voting of the questions. We will maybe not have the possibility to answer each and every question. So post your question, try to be as general as possible so that many participants are affected by this question and the answer. And also, if you see a question in the chat window which is affecting you, give it a thumbs up or give it a reaction so that we see that many persons are affected by this question. Right. Let's jump right into this. A lot is happening at the moment, and practically on a weekly, sometimes even on a daily basis, we hear news on tariffs potentially affecting Austrian enterprises. And we therefore try to be at the pulse of time, and we try to prepare you a comprehensive overview of US tariffs. And you can find that overview on our so-called info point US-Zölle. That's a page in German language. You can see the link on the slide as well. And my colleagues, they will kindly put the link into the chat window as we speak. Please note that we're not commenting or interpreting announcements. We're solely summarizing factual and legally communicated information. This can be through executive orders or other presidential proclamations, federal notice publications, CSMS publications, but we're not interpreting social media postings. They also happen to be out there regarding the tariff situation on this very web page. Good. Having said that, CSMS, CBP, what's that all about? Whether you're a beginner or advanced in terms of US tariffs, you've probably noticed that there are a lot of acronyms and a lot of abbreviations out there when talking about the US tariff regime. So I've prepared a quick cheat sheet for everybody so that you can help yourself and have these acronyms at your fingertips. Should also help you when following today's webinar, where we will use a couple of these acronyms as well. So let's go through them very quickly, starting with IEEPA. This is something you've probably heard a lot of. This is the International Emergency Economic Powers Act, which is a federal law in the US that authorizes the president to regulate international economic transactions during a so-called national emergency. So what you have to know here is that this is the legal basis for reciprocal tariffs, currently standing at 15% for EU countries. You've also probably heard about different sections based on the Trade Expansion Act of 1962 or 74. These are section 201, 232, 301. So what you need to know here is that also here, these are legal bases for additional tariffs apart from IEEPA. And we will speak about this more in detail later on. The BIS, the Bureau of Industry and Security, is the main federal agency responsible for enforcing customs law, including tariff collection and clearance of goods entering the US. So this is, sorry, I went directly to Customs and Border Protection. So this is the federal agency collecting basically the customs and being responsible for the customs evaluation. The BIS, the Bureau of Industry and Security, is a department of the Department of Commerce and is responsible for protecting the national security. This authority plays a crucial role when we talk about Section 232, which is today's topic. Maybe you've also come across the CSMS, Cargo Systems Messaging Service. This is the official communication tool of the CBP, the Customs and Border Protection. This is actually the source where we get the most accurate and latest information on US tariffs. HTUS is the Harmonized Tariff Schedule of the United States. That's the classification system for your goods being imported to the US. Note hereby that with the tariff codes, the first 6 digits of your HTS codes, they are internationally harmonized, and you need to pay attention to these HTS US codes, as these are the basis for the tariffs applying to your goods. The MFN is the most favored nation clause, a tariff status under which a country grants its best trade terms, the lowest tariff to its trade partners. And the US applies MFN tariffs as the standard tariff rate unless preferential trade agreements or tariffs apply. And last but not least, a very important organization or person, so to say, USTR is the United States Trade Representative. His office is responsible for developing, coordinating, and negotiating US trade policies with other countries. And that person, Jamieson Greer, he serves as the president's chief trade advisor and negotiator. So if you come across this abbreviation, you should know who we talk about. You can also take a screenshot if you want. As I said, we'll later talk about these abbreviations without explaining in detail what it means. So just a second to give you the opportunity to take a screenshot if you want. If that happened, we move on to the next slide, which where I wanted to tell you a little bit about the background of today's webinar. Why are we doing this and where are we at the moment? So a key happening from the past weeks or months was the EU-US trade deal, which was finalized in this summer and put into effect later on. This deal introduced a tariff ceiling, as we said before, of 15% on the majority. Here we see 70% roughly of EU exports to the United States. So this is an all-in tariff cap, meaning no additional stacking of duties will apply hereby. EU products with MFN tariffs of 15% or higher, they will not suffer additional tariffs. So here, the MFN tariffs is the valid tariff you have to look at. As you know, some key EU products, they enjoy zero or nearly zero tariffs as only the MFN tariffs apply. This includes aircraft parts, generic medicine, and natural resources unavailable in the United States, and some other products as well. You can also find a summary at the bespoken Zoll info point, which I mentioned before, and which you can see in the chat window to read further details about that. Having said this, it's also important to stress that the situation still remains very volatile. While the legality of IEEPA tariffs is currently under review by the Supreme Court, it is crucial to monitor the ongoing developments in the United States, especially regarding the sections 201 and 232, topic of today. These sections are continuously evaluated and can also elevate the current tariff rates. So today we're closely looking at the section 232 and the elevated tariffs imposed on July 4th. Heavily impacted are the 50% tariffs, especially when it comes to steel, aluminum, and derivatives thereof. We talk about 50% for these contents, but there's a lot to consider. And it's also worth mentioning that you need to look at the HTS lists of steel, of aluminum, of copper, because here you can see the HTS codes of your product and whether they apply to 50%, whether they're subject to 50% or not. And all about these details and all about the necessary information you should know in regards of section 232 will be presented within the next half an hour, 45 minutes. And it is my honor to now present to you our first speaker of today. His name is Joseph Maher. He's a partner of Nixon and Peabody, an expert and very dear to our office for quite some time, which I'm very thankful about. Joseph is a cross-border risk lawyer and a leading expert on tariffs. He's a leading national and homeland security professional who has also served at the highest level of the US Department of Homeland Security through 4 presidential administrations. So he really has the insight of what's happening in the US here. So having said that, Joe, what do you say? What should our audience think about the developments happening these days? Help us clarifying some issues and help us explaining what's important to understand as an European or Austrian exporter with goods exported to the US.
Thank you very much, Thomas. I really appreciate it. I appreciate being asked to talk to this audience because I know you have a lot of individuals attending who are sophisticated in their business enterprises and have a deep interest in this topic. And so I'm glad to be able to address you guys today. On the first slide, I'll just mention the 2 main topics I'm going to address are 2 types of tariffs that are, I think, of main concern probably to this audience. One is the reciprocal tariffs that Thomas mentioned, and the other are called Section 232 national security tariffs. And just to give you a little bit of a flavor, I think within the United States, the idea of these tariffs is a very kind of divisive issue. So there are some people that support the president's moves on this, but there are also a lot of people who don't like the changes that are being made. And so that results, I think, in a lot of uncertainty in terms of kind of going forward, the political nature of this, as well as some of the litigation that Thomas mentioned. So just to give you a sense, of what's going on inside the United States, that this is there's a lot of consternation, a lot of concern as well with the way the policies are going. So as a background, also in the way that these tariffs and tariff changes are announced is very atypical compared to how they've been announced in the past. So typically, tariff changes are either made by the US Congress or by agencies after a lot of deliberation. right now, a lot of the tariff changes come by social media posts, by tweets or things like that. Many times there'll be the president himself will tweet something out about a change in tariff policy. And we're often asked right away by companies what the effect will be. A lot of times we have to wait to see how the agencies underneath actually implement that. Because a lot of times the agencies themselves are learning about the policy change at the same time the social media post is happening. And so when it gets down to the details of how the changes are being made, the dates of changes, things like that, oftentimes you have to, that follows after the social media post. So that's just to give you a little bit of background as you are tracking these things in the news and hear different types of things. Now, we'll talk mostly about reciprocal tariffs and the Section 232 tariffs. But as Thomas mentioned, there are other important tariffs out there and other important duties out there that we're not going to discuss as much today, but you should just know about. So, for example, Section 301 tariffs, those are mainly for U.S. purposes applied to China. In the future, they could be applied to other countries, but it's a very big deal for people who are importing goods from China into the United States. And then, of course, there are anti-dumping and countervailing duties that can apply. So we'll go to the next slide. So just to give you the legal framework for the reciprocal tariffs, this is the 15% tariff that Thomas mentioned. This is based on a law that has not been used before for tariffs. It's the International Emergency Economic Powers Act. Typically, this law is invoked for other types of things and not to impose tariffs. But President Trump, when he came into office this January of this year, started using this law to do this. And under this law, he has to declare that there's a national emergency in order to use the authorities in this law. So he's done that in a number of different cases with respect to the U.S. border for Canada, Mexico, but most relevantly for this group, he's invoked it in order to impose the reciprocal tariffs, which he first announced in April. The other kind of distinguishing fact about this authority and the reciprocal tariffs is that there's no requirement for a lengthy investigation or seeking input from the public. The president basically can just impose it right away. And so that's why you've seen over the course of the past few months, the reciprocal tariff has changed over time. Most recently with an agreement with the EU, it seems to have settled at 15%. But if the president decided that he wanted to change this in the future, he could do this without any warning, essentially. For a lot of these reasons, that's why this tariff authority is being challenged in court. And I can go into that more detail if people have questions about that. But that litigation is a big overhang over these tariffs based on the Emergency Economic Powers Act. And just, as I'm sure you are all well aware, the order of magnitude here is huge. This, affects billions of dollars, US dollars of trade each year based on this authority. We'll go to the next slide. The Section 232 tariffs are different. So these are tariffs that are explicitly identified in statute where the US Congress has given authority to the president to impose these tariffs if there's a decision that certain types of imports or the quantity of imports is threatening to impair the US national security. So the most prominent example of this are the steel imports, steel and aluminum imports that the president has used to do this. Unlike the International Emergency Economic Powers Act reciprocal tariffs, these tariffs take a while to develop. So in order for these tariffs to be imposed, there's a multi-month process which involves an investigation, consultation, public hearings, before there's a final recommendation to the president to impose these tariffs. So this is usually approximately about a year-long process. If the president or someone in the relevant authority decides we need to investigate this area of the industry to see if there should be 232 tariffs applied. These 232 tariffs were first applied for steel and aluminum back during President Trump's prior administration. They were carried along through President Biden's administration, and the significant change in the current Trump administration was that he removed there were some exclusions and exemptions. So over the course of the years since this tariff was imposed, there were negotiated reductions for certain countries, and there were also exclusions allowed for certain types of products. That was all kind of taken away when President Trump reintroduced new rules regarding these tariffs this year. And so the tariffs are basically worldwide now. There are no exemptions for particular countries, although the one kind of notable exception is the UK has a different rate. So, but right now they're at 50%. We'll go to the next slide. So as we mentioned, these recently increased to 50%. They apply worldwide. It also applies to derivative products. So generally, steel and aluminum tariffs were applied to kind of bulk import of raw steel and aluminum. But there's what's called a steel derivatives list, which is a list of HTS codes for products that have steel content, steel or aluminum content, that the administration has decided that the import of those goods and the quantities can negatively affect the national security as well. So there are a number of different theories behind that. One theory would be that, if they were the types of derivative products that would be easily kind of manipulated to basically just try to evade the import of raw steel, that's one reason for inputting them onto the derivatives list. Another might be that if there are a number of these goods where manufacturers are purchasing the raw steel or aluminum to make these goods outside the United States, that reduces the U.S. domestic production capabilities. So anyway, there are a number of different theories as to how and why those might affect the U.S. national security, but the derivatives list is important for a lot of companies. There's no drawback available for this type of tariff, for those of you who are familiar with drawbacks. And kind of one of the important aspects of the derivative list as well is that if your product is not made of 100% steel or aluminum, the tariff, the 50% tariff, only applies to the steel or aluminum content and does not apply to the non-steel or aluminum content. For the non-steel or aluminum content, the reciprocal tariff, the 15% tariff generally would apply. We can go to the next slide. I wanted to just describe to you, because this is so important for impact on a lot of goods, tooling, machinery being imported in the United States. I mentioned there's a separate steel derivatives list, and there's related to that list, there's something called the inclusions process, which is a process that the president instituted and that the Department of Commerce runs that allows U.S. companies to request that the government add HTS codes to the steel derivatives or aluminum derivatives list. So this is there's a window of time during which U.S. companies can request this 3 times each year. Each time that window is open, it's for a 2-week period where they can send in a request and explain why they think that the addition of certain HTS codes is important to the national security, to the steel aluminum derivatives list. The most recent period just closed on September 29th. After this 2-week period where companies can ask to have things added, the rest of the public, foreign manufacturers, other parties, can see what was requested, and then they have a 2-week period to submit information or arguments to the Commerce Department explaining why they think those HTS codes should not be added to the list. So whether an HTS code is added to the list or not added to the list obviously can have a huge impact for companies because it's the difference between a 50% tariff or 15% tariff in general. So that's a very important thing. So we're right now in an open period where companies can see on the Department of Commerce's website which companies have asked for which additions to the derivative list, and can, if you'd like to, submit comments to the Commerce Department trying to argue that it should not be added to the list. For the times recently where the Commerce Department has considered these in the past, they have approved almost all of the requests to add things to the list. So that's an important detail. But this process is a very important one that may not be obvious to a lot of people. So we can go to the next slide. And I know Jim after me is going to talk more about valuation, and that is an incredibly important part of the import process. But one issue I just wanted to highlight that is very unclear and not settled in the US right now is how to determine the value of aluminum or steel content if you are importing products that are on the steel or aluminum derivatives list. So I put up here, and I'm not going to read it all, but this is the US Customs and Border Protection guidance on how to determine this valuation. But in its essence, it basically says that the value you're supposed to use is the total payment made or to be made for the steel or aluminum content. Now, I can tell you that different experts in the United States are interpreting this in different ways. On one hand, you can interpret it in such that the steel or aluminum content value is the amount that the foreign manufacturer pays for the steel or aluminum inputs into whatever products they develop overseas in manufacturing. Another way to interpret it is to say, no, it's the value of the steel aluminum content as it enters the United States. So it includes not only the cost of the raw steel or aluminum used to produce the item, but also the labor costs, the design costs, the profits that the foreign manufacturer is taking when it sells the good into the United States. The Customs and Border Protection is not kind of given further guidance other than what I'm showing here. But you should know that there's it's unsettled right now in the United States, I would say, is how I would describe that. And if we go to the next slide, I'll kind of explain why this is so important and why it's actually very important that we get clarity. And that's because President Trump, when he's issued these tariffs, has given very stringent instructions and executive orders to the enforcement agency that if companies get this wrong, that the enforcement agency is supposed to impose the maximum penalties allowed by law, and that they're not supposed to consider mitigating factors. So typically when U.S. Customs and Border Protection does an investigation and finds that a company has either used the wrong valuation, used a wrong classification, they will oftentimes consider what are called mitigating factors. Is this the first time that there's been a violation by this company? Was this a true mistake, or was the company trying to defraud the government? So they'll consider mitigating factors that could lower the penalties. But with steel and aluminum imports, the president has directed them not to consider those mitigating factors and to impose as stringent a penalty as possible under the law. I'll switch the gears a little bit to the next slide, and I know I need to turn it over to Jim soon. But just going forward, I think what I expect is and what we've experienced is increasing complexity with the way that the announcements and the rules are made. They're coming down. Because these rules are being dictated through executive order, there's a lot of complexity involved that sometimes isn't fully threshed out at the agency level. And so that causes issues. And I'll go to the next slide. One of the things that I think is also going to increase are enforcements and penalties by U.S. Customs and Border Protection. There are a lot of adjustments that the president is making to the U.S. government in terms of cutting different programs and departments. But one of the areas where he is increasing funding and increasing personnel is with U.S. Customs and Border Protection. And so there's going to be increasing enforcement. We're already seeing increases in requests for information from companies, things like that. But the types of things that they will typically conduct enforcement and penalties against are things like origin washing, which is basically if you try to change the country of origin of the goods you're importing to try to get a lower tariff. Oftentimes this is seen with respect to imports from China. Since the tariffs coming from China into the United States are so high, companies sometimes will try to transship them to a different country before bringing them into the United States. That's an issue. Valuation adjustments. If there's a significant change in how you're doing valuation, that could trigger a review by U.S. Customs and Border Protection. Classification adjustments. If you've been importing a type of product under a certain classification, for the past 20 years, and all of a sudden you change the classification, that could trigger a review by them. And then just a note here I have is that the U.S. Department of Justice issues public statements sometimes about what its highest priorities are in terms of enforcement. And they've listed trade and customs fraud as one of the areas where they are very focused on as well. So I think what all that just foretells is that we will likely have much more activity in this area. In the next slide, I did want to mention to you just the general basics of how typical customs penalties work. So if you get something wrong when you're importing things into the United States, oftentimes you can correct it before the entry is liquidated. And so your customs broker can make the change before it's finalized. But in cases where CBP, Customs and Border Protection, thinks that you're importing things improperly, they will do an investigation and they will determine whether your import practices were either negligent, grossly negligent, or whether they were willful or fraudulent. And the penalties change based on which category they think your conduct is in. So if your conduct is negligent, the typical penalties will be that you'll have to pay 2 times the amount of tariff that you otherwise would have had to pay. If you're grossly negligent, the general standard is you would have to pay 4 times the amount of tariff or duties that you should have paid originally. And then if you're fraudulent or willfully trying to cheat the government, you'll have to pay a penalty usually that's worth the value of the actual merchandise that you're bringing in. So these penalties can add up very quickly. There's some nuance that I'm not going to go into because of the time we have, but I just wanted to give you that general layout of what happens during an investigation and what the kind of conclusions could be. And then finally, in my last slide, I will mention I think there's going to be over the next couple of years some continued uncertainty. Some of that is based around the fact that the U.S. has ongoing negotiations and discussions with major trade partners. In addition to the EU, there are significant talks going on with Mexico, China, and others. I think that the predictability of the decision making by U.S. government leaders on tariffs is not as predictable as it has been in the past. I think that'll probably continue. And as Thomas mentioned at the outset, there's very significant litigation going on in the United States that would have significant impacts depending on the outcome of that litigation. And then I already discussed the enhanced enforcement that I think is likely ahead. So let me close with that and turn it back over to Thomas and Jim, and I'll be glad to stick around for any questions afterwards. Thank you very much.
Thank you very much, Joe. I think that was a very interesting insight in what's happening at the moment. Still a lot of uncertainty going on, and we can tell by looking into the chat window. So please also, Joe, take your time to go through the questions directed to you through the chat window. We'll try to answer them or some of them at the end of our session. And without any further ado, I would like to turn things over to our next expert, which is Jim Trubitz. You already switched on your camera. Very good. Hello, Jim. Jim Trubitz is the Vice President of Business Development at Mohawk Global Logistics, and he has over 40 years of expertise in customs compliance, free trade agreement, and supply chain management. He's a licensed customs broker and certified customs specialist and so he knows what the problem of companies is at the border with CBP. You see them daily. You have these issues on your desk, and will be happily listening to your expertise and listening to what is happening in your job these days and what to pay attention to. Thank you very much, Jim, for being here today, and the floor is yours.
Thank you, Thomas. I just want to add a couple things that Joseph said too. As customs brokers, we're seeing enforcement ramped up at the centers. So customs has set up 10 centers across the United States, and we're seeing enforcement where we were told by some of the import specialists that they receive daily changes on how an importer changes their value, their origin, their tariff, and they're reviewing that. They're also, as we're seeing, they're looking at, they're looking to see if, the importers are meeting their obligations. And one of the things that was significant that happened a couple of weeks ago is normally we would have a reject period where it would be 2 days for the reject. Customs is now is allowed a 10-day reject period. So we're seeing where shipments are being rejected, and we're being asked to correct them. So it may be that you think the shipment's been cleared, and then the broker's going back to the importer, or in some cases the importer is going back to the exporter and asking for additional information. Next slide, Thomas. Yeah. So I wanted to start with just a general concept of what U.S. Customs did over 30 years ago. So under reasonable care, they set a standard where there's obligations that the importer has to meet regarding tariff classification, valuation, and country of origin determination. There's other elements as well, but I wanted to kind of just mention this. These are the three we're going to focus on today. But this standard's over 30 years old, and part of the reasonable care was they did allow for experts to be named in this act as well. And those would be customs attorneys like Joseph, customs brokers, but they'd have to be a U.S. customs broker, and tax accountants, because sometimes you need to do, some formulation regarding values. And of course, U.S. Customs. Those are the experts. So, as you're going to see that companies sometimes, they're going on previous information, but it might not be showing the reasonable care that you need. So it may be that you're going to see a lot more inquiries from U.S. importers on you as an exporter to make sure that you're getting the right information on your documentation. Next slide, please. So we're, as an exporter, and possibly, companies that are on here today that are importers, the sheer size of the harmonized tariff system in the U.S. is massive. We're already at our 24th revision, and we're not even through the year yet. There's been years where we've had maybe 1 or 2 revisions. One of the things that we've been experiencing a lot is that we're seeing where companies will say, but we're allowed to use this tariff code for our export purposes, or we've always used this tariff code versus using the U.S. tariff system. And that, believe it or not, U.S. Customs is really starting to push back on that. And so they're saying, the section note excludes this, things like that. So it's so important right now that you may even have binding tariff information, a BTI, that says your goods are classified this way. U.S. Customs will not always recognize that. So you have to actually go to the binding rulings under cross and look at those. Even with that, it's best to consult with an expert. And this is not some shameless plug. I'll give you an example. There's a binding ruling in cross that indicates that the goods should be classified a certain way, but you have to refer to a court case that overturned it. So the cross rulings don't always reference court rulings, so you have to kind of navigate this and make sure you're getting it right. And then on top of it, we have special provisions in Chapter 98 that importers take advantage of. But more important, Chapter 99, these 9903 numbers, we had 9 pages of 9903 numbers at the beginning of the year. We're already over 20 pages of 9903 numbers. So, and Joseph said this earlier, and this is probably very important. If you're going to make any changes to your tariff, you want to document carefully why and how you determine that change. And I can only speak for myself. The majority of my time right now is spending doing tariff reviews. Next slide, please. So, obviously your exports ride on paper. And so Customs has now been focusing on a couple of different things. And Joseph alluded to this earlier. Obviously country of origin is very important. And so we'll go through this every once in a while. I just went through this with a 3D printer where they said the PCBAs and the PLCs, which is a programmable logic controller, where those were made is the country of origin of the goods. And so this is something that you want to pay attention to. And then this one has become so critical. A lot of exporters' systems have vague descriptions, or they'll use some system that identifies a part number and maybe their model number or something. Customs is now looking for complete and accurate descriptions of the goods, and they need to match up to your tariff number. And we had an example this morning where someone sent us over something and we didn't know what it was. We actually asked the exporter to update their invoice to show a complete and accurate description. That being said, right now, we are seeing regular requests daily where Customs is asking for us to upload the documentation. So not all shipments are looked at, but now they're asking for that documentation in advance. And if they feel the description doesn't match the tariff number, they're rejecting the entry. And then, obviously we're getting into a situation with a lot of the 232s where we need to have that mill test report. It's got to have that country of origin. It's got to have the melt or pour or the smelt and cast. So these are very important things that we're now need. And, without them, that shipment could be delayed or rejected. Next slide, please. And one of the things I wanted to mention too, I always recommend to exporters or to U.S. importers that they reach out to their broker and ask them, is my documentation complete? Is there anything I'm missing? And here's a great example. So 14189 of the regulations has been around forever. But now Customs is asking more and more on this. So, obviously, it goes without saying for steel and aluminum articles, but ball and roller bearings, they actually require some detail. And we actually have a worksheet on our website, and I'm sure your broker might have them as well, where you're going to download that information. But they're looking for this information on an ongoing basis. But probably more important is if it's a machine, if it's a machine part, they want to know the end use of that machine. They want you to be more detailed. You just can't put milling machine. They want to know it, greater details on that. So you're going to want to work with your broker, or or the importer is going to want to work with that broker and make sure that your description is complete and accurate. It may mean that because of limitations on your ERP system, that you're going to supply a supplemental document, either an Excel or an ad sheet of some sort. A lot of times what we'll do is we'll work with the companies involved and add a supplemental description. But you're going to have to do something along those lines just to protect you. Next slide, please. Okay, so this has been kind of stressful for everybody. I don't know any other way to put it. We're now seeing this for, you got aluminum and steel. You actually have it for copper as well, where you're actually having to report different values, different quantities, and for the aluminum, steel, we need to know the value of the fabricated article, and that article's weight in kilos. So we're reporting that. If we have it unknown, then we have to report the whole thing as dutiable. And this is something very important. The other thing I wanted to mention here, and this is something that we went through back in recently, where Customs issued a notice saying, if the origin of the aluminum is unknown, then we have to put it in as unknown, and it's now dutiable at 200%. So you're going to see, and Joseph talked about this with transshipment earlier, where we are really experiencing difficulties. So far, if we don't know the origin of the steel, and we put down that it's unknown for a derivative, we're okay. But for aluminum, if it's unknown, it goes to 200%, as if it was Russian aluminum. Next slide, please. So back in 1980, all countries pretty much went under transaction value. So transaction value, it was the standard. And they used this so we could go forward with free trade agreements, et cetera, et cetera. But your invoice value sometimes needs to have additions. Next. Yep. So these additions could be assist. If you have packing and it's separate, and so anything that's not included in that amount, that could be like a selling commission, packing, assist, they would have to be added in. Next. Yep. And then subtractions. And this is where it gets interesting. So international transport and insurance. So into Europe, your value is based on the CIF or the DAP value. In the US, if the freight's included and we can identify it by the exact amount, it's a deduction. It's called non-dutiable freight. And we base our value for duty on the actual entered value less that amount. So it'll be either the ex-factory or the FOB amount, which is advantageous. And if you have insurance, or if you're going to quantify it in your contract that you're going to send someone over and they're going to set up the machine and there's travel expenses and everything, and you quantify that differently, that's an allowable deduction as well. If we have any companies that are exporters that are on the phone that are also considered a non-resident importer, and the duties are included in the price, that's an allowable deduction, and that will get you, you can advance the slide here. To the transaction value. And that's the value that customs you'll be paying your duties on. Next slide. Okay, and Joseph and I both touched on this. Joseph talked about this. So I have some companies that do a lot of derivative materials. And I went to the center that I work very closely with this one importer. And I went and asked the question for weeks on end. They finally got a message back from the center in Chicago, which handles steel and aluminum and base metals. And they came back and said that, you know, that enter value should be the raw materials plus the conversion costs. So, you know, if you have a mold and you're selling that mold for $1 million, but it only includes $10,000 in steel, customs is viewing it as the total price paid or payable for that mold. Next slide. You know, here's what customs is focusing on right now for valuation. So if you have a related party or a transfer price, they're looking at that. They're looking at non-dutiable charges. So if you're deducting freight and insurance, they're looking at that. If they're sending out a notice requesting more information, which we call a CBP 28, they may be asking you, did you have any goods that were supplied to you free of charge that you're adding into the thing? And that's called an assist. They're also looking at the valuation of returns. And then they're also looking at repairs. And then if you have a no-charge item you're sending to the U.S., they're looking to see what the market value would be on those. Next slide. This is just a quick guide. So U.S. Customs has different informed compliance publications out there. They have them on all types of valuation issues. This is a great one if you want to make sure that you're deducting your freight properly before you pay duties. Next slide. So this is becoming more and more important. Customs is really looking at origin, and they're also looking at the marking of the goods. So as you can see that, you know, next slide, these are the requirements in reasonable care. For you to know the country of origin of the finished article. And this one has become nuanced or new, and that's knowing your next tier level of sourcing. And so everybody now is starting to have to know more and more about their supply chain. And your purchasers in the U.S. are asking you more and more detailed level on the sourcing of the raw materials. And then, of course, your goods have to be marked properly. Okay, next slide. So one of the things that I want to talk about, and this is probably one of the most important things, it's one of the requirements under reasonable care anyways, is the importance right now of checking your entries. So maybe it's not you, but it might be your importer in the U.S. For them, that due diligence is so important right now that they're checking their entries for accuracy. It's as if they're checking their credit card statement. This is going to become more and more important. The other thing I would recommend, again, and I said this earlier, is they need to be working with their broker to review their invoice descriptions. That is so critical. And then we're now getting into this sourcing level where if you have U.S. content, depending on circumstances, it may help mitigate the amount of duty you pay. How important now it is for aluminum, steel to be, content to be provided by weight and value and stated on the commercial invoice or some ad sheet, plus the importance of providing that mill test certificate. We're seeing an increase in goods being claimed under Chapter 98. Work with, the importer or, the actual broker, if you're working with them, and make sure that you have those supporting documents. Customs is looking at these claims very carefully. They've seen significant increases in them. I know for a fact that temporary import bonds is an example. Customs has seen a 200% increase in temporary import bonds since the beginning of the year. So they're focusing a lot on this right now. Thank you, Thomas.
Thank you very much, Jim. And I'd like to ask you to keep your camera and your microphone on. And also I would like to invite Joe to switch on his camera and his microphone as we now are reaching the last agenda point of today, which is the Q&A section. As you could see, the questions are piling up in the chat window, so we'll try to prioritize them. Drop your questions here and also like or comment other questions made by other persons whenever you're affected. So, gentlemen, I would like to maybe read out the questions in the chat window. There's one with which has 12 reactions, and is the most popular question. Maybe, Joe, I would like you to address the question first, and maybe, Jim, if there's something to add, you go second, if that's okay for you. The question goes as follows: assuming I import a product to the US that is affected by Section 232, and I receive the value of the steel content and the weight of the steel in the product from the supplier. Is this information sufficient in written form in an email, or must it be stated on a commercial document, let's say an invoice or a delivery note?
Yeah, so Jim will probably have a good view about the type of documentation he'd prefer to have as a customs broker. I think it's probably always a little better to have it on an invoice or other commercial document than just an email. But for these purposes, I think CBP has not given clear guidance as to what type of documentation exactly needs to be had here. So I think kind of the more documentation you can have, the better. So if you're able to work with your supplier and have them add this information to the invoice, I think that's a little better. But I apologize for not be able to give kind of more clear, kind of concrete guidance, just because the agency itself hasn't done that yet. And Jim, I don't know if you have anything you want to add to that.
Oh, I got something for you guys. So Thomas and everybody, I will send you a Chicago pipeline from 2010. That basically said, look, we understand that people have limitations on their ERP systems, and an ad sheet of some sort will work. So I'll send that to you, and that shows that they're exercising reasonable care.
Very well. Let's carry on. We have another question regarding copper. So maybe, Joe, you can address it first, since it was the question was asked during your part of the presentation. It says the shipment of replacement cables, 3.2% copper by value, was classified under Section 232, although it is a finished product, not raw material. How can the documents be adjusted to reflect the correct classification?
I would have to look more at the copper, the regulation on copper. I'm just I assume by the question that finished products are excluded from the 232 on that. But I think it goes back to one of the points that Jim made, which is you have to have a clear description of the article that matches what you're trying to do. So if the basis for excluding it is that it's a finished material, finished product, I think you have to make that clear and then work with your customs broker to make sure it's documented the right way.
I can address. I know that there was only 4 items that were 8544 that were subject to the copper derivative. And with that being said, it'll be important that it captures the fabrication cost as well. So it may be that, you might have the sheathing and possibly the connectors that are non-copper on there and are not affected, but they would have to show a quantifiable amount and give that to the broker, and the broker can do a post-summary correction.
Good. Let's carry on. It's difficult to go through all the questions because there were so many. Maybe let's touch base on the following issue. I think, Joe, you already answered it partially, but it is about exporting products as a compilation of goods under HS, which is not affected by Section 232. I think that's interesting for many persons. Some parts are made of steel. Are those parts affected by the 50%? I think you referenced to the HTS list, so it's worth repeating that maybe.
Yeah, so not everything that contains steel being imported is impacted by the steel tariffs. It's only if it's a core steel product, which then the entire article would be under 50%, or if it's a steel or aluminum derivative product. And so if it's not a steel or aluminum derivative product, but contains some steel, it's not tariffed under the 50%. So you need to look at the HTS code that applies to your product and see if that HTS code is on the steel and aluminum derivatives list. And if it is, then you need to pay the 50% on only the steel or aluminum content of the item and not on the non-steel or aluminum content.
Right, and just because I see it popping up, the question, where can we find the HTS list? So we are happy to provide this information. And as I mentioned in the beginning of the webinar, we also have a summary of the most relevant US tariff regulations going on at our webpage, wuk.at, which is the Zoll info point. We'll distribute this information to you, and we'll also highlight the HTS list for aluminium, the HTS list for steel, so that you can check if your goods are affected or are in this list. And also, as Joe and I think also Jim mentioned, if at some point your good is not on the list, please don't be too sure that this won't change, because as I mentioned in the beginning, these HTS lists are subject to constant evaluation and they are being constantly expanded. So that means in the end, if your HTS code is not on the list as of today, that could change as of tomorrow. So make sure that you're up to date, you have the latest and freshest HTS lists, and browse through them before dispatching your goods.
Yeah, I think that's a really important point. And the latest addition to the lists were in August, where they added about several hundred additional HTS codes to the lists. And they're currently in that process now. I would expect probably either late October or early November, they will kind of add additional ones. So that list does evolve.
Some more trouble on the way, so to say, from the Austrian perspective, at least. Jim, I have one for you as well. It was mentioned that the determination of the value of aluminium and steel content is not settled. Does that mean, could it work for an exporter to split the value of a product, for example, to list the value of the raw steel and then finishing, printing, shaping, finishing, whatever, as 2 extra lines on the invoice? And would this mean that the basis for calculating the 50% tariff would be many times lower, as it's only the raw steel?
So this is going to be one of these that I almost feel like Joe should be answering this one, because it depends, right, Joe? You like that? What it's going to come down to is, we think this is going to wind up in court at some point, and so we believe that customs is basing it on the price paid or payable, and with that fabrication cost included. Will whoever win out in court? It's hard to say, but customs is intending right now to go and start advancing the values on some of these entries. That's what I've been told by customs. So, Joe, your thoughts?
Yeah, I think Jim's right. As I think we both mentioned, we can't give concrete, conclusive kind of guidance because the agency itself hasn't. But I think Jim's right. There are some importers that are basically just using the raw cost of the input material as the value. And I think, I personally would not be advising people to do that. And it sounds like from what Jim's seeing in the field that's CBP is starting to rate advance, which suggests that they don't think that that's the right answer either. That basically you need to look at the value of it as the good is sold from the foreign manufacturer to the U.S. importer, which would include a lot of other costs that Jim mentioned for the valuation, not just the pure cost of the raw material that goes into it.
Right. Joe, maybe you can also elaborate on the question which you have already answered partially in the chat regarding, I think it was a rather detailed question, so maybe we'll need to tackle this in two parts and get to the person back later on after this webinar. But maybe you can quickly address the points which that there was this question regarding 4 or 5 points, steel and aluminium duties, and you gave a quick summary. Maybe you remember the question, so I don't have to read out everything because it's a rather long text. But maybe you can point out the essences for the entire audience, please.
Yeah. So I think as we discussed before, it's only if your product is on the steel and aluminum derivative list that you have to worry about parts of that are steel or aluminum being under the 50% tariff. So if you look at that and decide that, yes, your HTS code for your overall product is on that list, then you have to be worried about the steel content and having the 50% apply. We talked about the documentation for the melt country. So this person's right to point out that if you're using steel that has been comes from the United States, so it was melted in the United States, you import to your foreign manufacturing facility U.S. steel to use to make your part of your components. There's a 0% charge for that. He mentions that if it's melted in the UK, I would need to double check, but I think that 25% rate for the UK only applies if the item is being imported from the UK. So if you're in Austria and you're manufacturing a good and you get UK steel and then import your product, you manufacture it and you import your product to the US, I don't think you get to do the 25%. I think that's only if the good is coming from the UK. And Jim can check me on that if he thinks otherwise. But
I'd have to look too. Yep.
Yeah. And then for Russia, the 200% is for aluminum. It's not for steel. So that's for aluminum products. And that's part of the reason why you need to know the kind of history of where the product came from so that you can rule out the notion of having to pay the 200%, assuming the aluminum input came from somewhere else.
Good.
I'll throw the CSMS message in about the unknown for you as a reference.
Another just point about valuation that we've been talking about for the steel aluminum content. CP has said that if you're not sure, if you don't know what the value is of the steel or aluminum, you're supposed to treat the entire article as if it's under the 50% tariff. So if you have an item that's on the steel or aluminum derivatives list, and it's either 95% steel or you just don't know, the CP takes the view that you should be applying the 50% tariff to the entire item. So it's in some situations, it may not be worth your while if the good you're inputting is 98% steel. It may not be worth your while to deal with the logistics of having to kind of separate out the content. Maybe just be worthwhile to pay the 50%, but that obviously depends a lot on your particular products and processes.
We also have a question, and I think that's a quite common one, and I'm afraid there's not a 100% clear answer to that, but we'll try to tackle that. You mentioned already important parts during your webinar, but here's a question on more guidance of how to calculate the metal value for goods that contain a metal derivative portion. I'm trying to summarize the question. So basically, it is unclear how much value the steel in a product has, which is on the HTS list. So it's subject to the Section 232 tariffs, but it's not clear how to do the calculations. We already mentioned what we do if the value is unknown. We already mentioned that documentation is very important. Can you give some additional information on how to do the calculation, going back to the supplier, going back to the invoice of the supplier, or what are guidances you could give to our audience here?
Yeah, I can kind of give you a broad view of how I would advise on that, but a lot of it does depend on the details. So you really need to look at the details. But I would say, from my view, I would advise to take the more conservative approach that you would value the steel content by looking at the cost of the input steel, but adding on to that, the costs that it takes to design whatever portion that you're manufacturing with the steel, the labor costs associated with that, and the profit that the foreign manufacturer is earning when it sells the product into the United States. So adding up those factors, I think, are important, and kind of having documentation to support those. So I know that's a more conservative approach than some others are taking or advising of taking. But the reason why I kind of would approach it that way are two reasons. One, because of some of the things Jim has said about what he's starting to see in the field indicates that CBP seems to be going that way, but also because the president has been so adamant about CBP imposing maximum penalties if people get this wrong. Those penalties can be significant, and you don't want to be on the receiving end of them, either in terms of a protracted investigation or having to pay significant penalties. So that's kind of where I am right now, but let me turn over to Jim for any thoughts he has.
I agree. I agree. And unfortunately, you have to use some reasonable care on this and do your best. And some of them are real straightforward. I have one right now that has a perfume bottle, and it has aluminum cap on it and a steel spring in it. So they're declaring the value of the spring they purchased and the cap they purchased as separate items, and so they're only paying the 50% on those two items. But it's extra work, to say the least. And if you look at it from a broker's point of view, we went from having 2 lines on a per classification up to 18 now. So it's very complicated, and people have to be looking at their entries right now. I can't stress that enough. You know what I mean? I don't know if that answered that question, but that's kind of what we're seeing.
Yeah, and I think just to add on that, because we also have a couple of questions where the audience is complaining a little bit about no clear legal instructions. So we do hear that. I think we can agree on that. They say that, for example, I have one comment here asking 4 different lawyers and authorities. We've got 4 different answers. Is there already a final legal official info to that? I might pass the bad message to you, so you can communicate that. But I'm afraid there's not the one way. So I think you have to make sure that your documentation is as clear and as justifiable as possible. But we also experience here in our office that if we ask several experts, we might receive several answers. So maybe Joe and Jim, some final comments on that, because we're in extra times already, and then have 1 or 2 questions more. But maybe your comment on best practices and final legal official infos.
Yeah, I apologize that it's not clearer than it is, because I know it can be very frustrating having to deal with this in real life and as you're bringing in goods. And I think the only thing I think I can add to that is that I think there is pressure that is building on CBP to come up with additional guidance on this, because I know that there are many people that are asking them. I think CBP understands that the issue is not clear to the industry. So my guess is there will probably be movement on this. Hard to predict when exactly that'll be, if it'll be within the next month or whether it'll be several months. But I do think that this is an issue that they are feeling pressure on. So.
Good. Let's do one or two more. Maybe you can update us also on the status for wood. There's also some 232 investigations closed at the moment, or as of last week, they were published. Joe, can you maybe give us 2 sentences on wood?
Yeah, so there was, as you mentioned, there was a recent 232 announcement with respect to wood products. It also includes not just kind of raw wood materials, but some finished products like cabinets, furniture. There's a lot of people who question whether those things really threaten the national security of the United States, to have additional furniture imported into the United States. So I think typically it's very difficult to challenge legally a president's determination with respect to something that impacts the national security of the United States. So for that reason, I think it's very unlikely, for example, that the courts would overturn the president's decision with respect to 232 tariffs on steel, aluminum, copper. This one, though, with respect to wood and wood furniture, I mean, that really, I think there'll be more people who may be willing to litigate that and challenge his view that impacts the national security. Who knows? It's hard to predict what the courts will do with that, just because traditionally courts really do give a lot of deference to the president on determinations with respect to national security. But if there was one at the outer bounds where I could see a court not giving him that kind of deference on this issue, the impact of wood furniture on the U.S. national security might be the case that does that. So yeah, that's an ongoing issue.
I agree with you. The other part of this is that this is a two-phase, because we got the one that's coming in on the 14th, but then January 1st, it's going to increase. So that's what I'm most worried about is, you're going to see, a lot of stuff being impacted. And of course, 232, you're not allowed to do duty drawback on.
Good. And ultimately, because we are we exceeded our time today by almost 20 minutes. So let's close with one last question. It is about best practices and guidance. So we touched base on this, but here's maybe a call of action from our side. Since we as Advantage Austria deal with a lot of questions alike from companies, please also give us feedback how you did when completing an import, how you did. Give us feedback so that we can share these best practices with other companies. So as far as I know, Joe and Jim, maybe you can add to that. There is no best practice platform, or companies are not really exchanging thoughts on that, unlike maybe bilaterally, but there is no public platform, I believe, where experiences are shared. And also the CBP guidelines are a bit vague, to put it that way. So I would suggest, and we do have a couple of information from companies, please refer to us and also tell us how you did, so that we can inform other companies about best practices.
Yeah, I will say
having said that, sorry.
I was just going to say that there is a lot of guidance on CBP's website. So for a lot of issues, we've been talking today about a lot of issues where they haven't given a whole lot of clear guidance, but there is a lot of guidance on their website that does help, especially if you're talking about kind of the basics of classification, valuation. There's a lot of information publicly available there that you can kind of pull up pretty easily that gives you some pretty good guidance. So.
Okay.
Yeah, I can add to that too. If they go to the customs rulings, a lot of times they can look up a similar product and they can use some of that wording that customs describes it as, add that into their description. And that's a lot of what we do sometimes when we work with an importer to make sure that their descriptions are better. And sometimes I'm working with a company right now where their description was confusing. They've always used it, but now we've realized that they were using the wrong description for years. So this is something that we've really increased, strengthened that description, just so if customs comes and looks at the invoice, they're going to go, oh, this isn't this, it's this. Leave it at that.
So I believe the longer we talk, the more questions we have. So we have to stop at some point, I'm afraid. So not all the questions were answered, but please feel free to also reach out to our two experts. They were kind enough to also provide their contact details on the presentation on the slides, which we will distribute to you, and make sure that your questions are being answered, if possible. I'd like to comment here. So I hope that that we have informed you sufficiently today about the section 232 updates. I do believe and I do see that there is a demand for further updates in the future. So stay tuned on upcoming webinars of ours. We'll do more on the questions relevant to you. And as I said, please also feel free to reach out either to us or to our esteemed speakers who left their contact details also on these slides. Yeah, thank you so much, gentlemen, Jim and Joe, for your time. I'm sorry for exceeding, but you can see that there's a lot of demand for information, a lot of thirst in Austria for information on tariffs. The situation stays volatile and complex. It's also worth mentioning that cases need to be evaluated individually because there's very seldomly a general answer to a question. So make sure to turn to your experts, make sure you do a right documentation, and make sure you use the sources we provided you as of today. Having said that, gentlemen, Joseph and Jim, thank you very, very much for participating today. Thank you also on behalf of our audience that you joined today and stayed a little bit longer. And to the audience, wishing you all the best, thanking you for your participation, and wishing you a great day or evening, depending on where you're joining us from.